Okay, let's go on the record on cause number DC 1716115, Bank of America NA versus Pure Dentistry PLLC. Counsel make your appearances, please.
I apologize, Judge. Chris Fussman for the plaintiff.
You're just very eager.
Yeah, right.
Your Honor, Michael Stein, the court-appointed receiver.
Your Honor, this is Rich Roberts for the judgment debtors.
Okay, I thought this was a really interesting motion that has been filed here, Mr. Roberts, because this has been an area where a lot of judges have been talking about this new phenomenon, or relatively new phenomenon, where we have these receivers kind of appointed in cases like this, and a bit of a they're pretty prolific. And so I was interested in your arguments here that maybe this isn't the way to approach this. And so, Mr. Roberts, I'm going to let you go ahead and make your argument.
Thank you, Your Honor. As we mentioned in our motion, so we're here on an interesting procedural posture where it appears that they took an old motion, they slapped a new case style on it, and they didn't get all the names correctly revamped. So Your Honor issued an ex parte receivership, which is permitted. That's fine under the statute. But as a result, we didn't get a chance to point that out to Your Honor. And the original receivership doesn't apply to my clients, and they're trying to fix that right now. We have a couple of different arguments. First, Mr. Stein is the receiver essentially over nothing as it stands right now. And so we don't believe that he has standing to bring this. That's a minor point. The larger point is what Your Honor mentioned. And it's really interesting to hear that the judges are talking about that, because I've noticed that as well. This is not the first receivership over a judgment debtor case that I have seen. And I've done some judgment debtor work and creditor work over the years. I've been on both sides of this, and there has been a proliferation of these receiverships. In my experience, I've done a lot of receivership work over the years. In my experience, receivership should be considered a fairly extraordinary remedy, because receivers have fairly extraordinary powers. And here, they've offered literally no evidence of any non-exempt assets. We can argue about this notion of whether or not the change in the statute requires them to show that they're not subject to ordinary execution. There has been a change in the statutory language that's not been addressed by the courts. So the law that we cited still stands. But even if it doesn't, they've offered the court literally no evidence of anything. They've offered the court no evidence that they've tried to execute without success. They've offered no evidence that my clients have been unresponsive. In fact, the evidence is to the contrary. If you look at the docket, the officer's return for the attempt to execute shows that they let the officer in, that he looked around, that he didn't find any non-exempt assets. We didn't put it into the record, but as an aside, I'll tell you that there were settlement discussions pre-COVID, and my clients believe that there was a settlement, an agreement to have this thing resolved. That fell apart during COVID. And so here we are now that they're trying to collect. So their reply attempts to fix this. They attach some documents that are unauthenticated, unsubstantiated, basically hearsay, but they still don't really address the issue. They try to say, okay, well, we found this thing on the internet that says Dr. Casa either works at or owns this Asana Dental. Well, she doesn't own the Asana Dental. There's a PLLC that owns it. I spoke with my clients earlier. There's a PLLC that owns it. If they want to execute on that, there is one remedy and one remedy only for that. They should get a charging order. The law is crystal clear. So really what they're trying to do, essentially what I think litigants in their position are trying to do, is they're trying to get the courts to sanction some receiver who can come in and do whatever he wants and take this out of the rightful realm of post-judgment discovery and court oversight of those things. And, you know, I've had some correspondence with Mr. Stein, and I asked him, we attached an email. I said, hey, look, what are the non-exempt assets? Let's talk about that. Let's see if we can figure something out, because we certainly don't want to rack up a ton of legal fees. And they refused to answer until we filed our motion, and they had a response date late on Friday. So we're asking the court to deny this, at least give the parties an opportunity to go through ordinary post-judgment procedures, before offering what we think is the extraordinary remedy of a receivership.
Mr. Fusselman?
Your Honor, I joined in Mr. Stein's motion for a reason. I've obviously practiced before the court before on receivership issues and turnover orders, and I hope that the court appreciates the fact that I'm willing to give great leeway to defendants in matters like this. What I will say is that there was a prior attorney named Mark Hanna that was working this file for the defendants. And on January 24th, 2023, he told me that they'd settled a judgment that was younger than ours with Frost Bank. Now, he didn't say what they used to do it, but he said they did it and they were paying it. And then they would get around to talking with us, which they didn't do. And at that point, and with warning to Mr. Hanna, I filed the turnover application. That's where this stands. We negotiated with Mr. Hanna for 6 months and got nowhere. The defendants turned the execution officer away, saying, oh, we got nothing, but by the way, we think we had a settlement agreement and I've got a lawyer, you need to talk to him. We're not getting cooperation from the defendants, Judge. They're not making efforts to satisfy this judgment. They're making efforts to kick the can down the road over and over again. Now, I will do whatever is required to get there, but we both know that this matter isn't going to get resolved until there's a receiver in place to discover, to receive evidence of these assets, which they've not produced so far, and to try to find an orderly way to liquidate those assets in an orderly way to satisfy this judgment. And that is what we're asking the court to do. Now, they say that order doesn't look the way they'd like it to look. And the receiver and I have agreed to make it look the way they want it to look so that there's no more question about who the judgment debtors defendants are in this case, so that discovery can go forward and we get down to the business of liquidating the judgment. And that's where the plaintiff stands today.
I think there's a kind of a bigger issue here. There has been an explosion of these types of receivership, requests. I've been on the bench for 17 years, and it is a huge change on the way this is. And I'm not necessarily saying it's wrong. I'm just saying that we see a whole lot more of these than we used to. And Mr. Roberts, who's a very good lawyer, he's been on my court before, is, I think usually in these cases that, you're suing folks who don't have a lot of assets and you negotiate something. And in this case, Mr. Roberts is kind of holding your feet to the fire to make sure that we're doing this correctly. I'm concerned that this explosion of these types of cases, are we really doing justice here with the courts? And so I'm going to ask you both to brief this issue. Is a receiver even appropriate at this point in this case? So, I will tell you that my goal is that based on your briefing, I just have a bunch of interns starting today. One of them is going to write a memo that I'm going to read, and if I feel it's appropriate, I'm going to share with all the other judges in Dallas. So I'd encourage you to brief this well on both sides. I'm not going to give your names or anything. It's not, I don't want you to think that, but I do think it's an important issue. Is it appropriate? Is what we're doing here with an explosion of receiverships, is it an appropriate remedy, or should we be taking a closer look at each of these orders? I get so many of these, I tend to, process them, and I'm wondering now if that's really I should give it more scrutiny. So, Senator, does that make sense to both sides?
Judge, that makes sense to the plaintiff.
Yes, Your Honor, it does. I'm sorry if that didn't come through.
Could
Yes.
you give me a short brief or letter brief within the next 4 days by Friday?
Yes, Your Honor.
Yes, Your Honor.
Okay. Mr. Stein, do you have any questions?
I don't have any questions, but I will, Your Honor, I've been doing this for over 2 decades, serving as a court-appointed receiver. And the answer to your question is actually statutory. It's the statute provides that this is a remedy available to creditors in the situation of the plaintiff. You are correct. It is an area of the law that has expanded greatly but is also one of the most efficient ways for collecting a judgment, especially when you have judgment creditor debtors who are not cooperating, who are not producing documentation, who are not appearing for deposition. You know, it's very typical to have a receiver appointed in those instances. And the statute provides that a turnover receivership, that a creditor is entitled to it. So it's not, I hope that it helps you with the question. I have presented CLE to the Harris County District Court judges at their event that they have for the judge CLE, and happy to share whatever information I
Yeah,
can.
why don't you share that with Mr. Fusselman? That might be helpful for this. So, all right, get those to me by Friday, the additional briefing, and you guys have a great rest of your day. Do you have any questions for me, Mr. Roberts?
I don't believe so. No, Your Honor.
Mr. Fusselman?
No, Judge, I'm familiar with where we're at here.
Okay. All right. Thank you, guys.
Thank you, Your Honor. May we be
Thank
excused?
you, Your Honor.
Judge.
You may. Is anyone here on the dismissal docket? I think Ms. Gandara, you're here on the dismissal docket. Ms. Gandara, are you here on the dismissal docket?
Yes, good morning, Judge. I am.
That's all right.
On Lorena's.
Yeah, so Rhonda, she's here on. Do you see that, Rhonda?
Yes. Mhm.
It's DC 228978. Ms. Gandara, what's going on with this case?
That case, we still have been unable to find the defendant on social media. We haven't been able to find him at all. We do have a 106 affidavit for a motion to substitute.
Have you filed it or?
Want to go that route? We really speak with our client. This is a case where they've I looked into the negotiations with the third party insurance. They've never accepted liability. I don't believe the defendant ever cooperated with Falcon Insurance. However, I question Falcon Insurance.